I've said it before, but I really want to say it again today. I just love when we come up with something and we discuss it here together, and then it shows up in the case that we've been discussing. When I first read the New York Times motion to dismiss, I felt like the case was pretty hopeless. When you're coming up against an institution like the New York Times, it's almost always futile. With its long standing in New York City and all of the rulings in its favor, it's only gotten stronger, and that's why I portrayed it in the thumbnail as having a great wall around it. So I always try to test myself and look at these cases and see if we can figure a way around something that seems to be an obstacle that just cannot be overcome. I mentioned it before. I noticed how much they kept saying New York law, New York law, New York law, and it kind of felt like the lady doth protest too much. But when I sat down and really read it through again and again, that's when I made that particular episode with this thumbnail. Because what caught my eye, and we've talked about so much here, is that line in the third paragraph on page 1 of the New York Times article about thousands of pages of texts and emails. And if you've seen these recent episodes, you've heard me say that so many times. Now we get to see it put so much more eloquently than what I was able to do in this latest filing. This is Legal Updates with Cassidy. Time to bring that wall down. Welcome. So we have another beautiful document by Mitchell Schuster and Brian Friedman. And shout out to Mitchell, who gets left out most of the time, with Brian Friedman getting all of the attention. Let's put both names out there, because these guys are working great together. I don't know who actually writes these, but I always love just that little bit of spice in them. For instance, this very first line starts off amazing. A pietistic bastion of the media establishment. So basically, this sacred bulwark, or this institution that fights and upholds principles or beliefs. And they might be using that sarcastically, I'm not sure. The New York Times has long presumed itself beyond accountability. Haven't we been saying that? And then the next sentence is one of the most powerful, even though it's only 2 words. Not here. Now here's the part we've been saying since we saw their motion to dismiss. The New York Times went past merely reporting on Blake Lively's CRD complaint and actively vouched for the veracity of its false narrative. The fair report privilege the New York Times seeks to hide behind does not protect it from liability for maliciously colluding with Lively and her cohort to publish a false and defamatory hit piece about the Wayfarer parties. So, they try to hide behind this fair report privilege. But as we've discussed in the last 4 or so episodes, this fair report privilege that they're claiming covers judicial proceedings. It can extend to documents if they're part of a judicial proceeding. But the New York Times told on themselves, and we'll get to that in a moment. But they did so in such a way that they've stepped out from under this fair report privilege. They mention the article and the video, and what's really great is they include the transcript of the video. I've not seen the video myself. I subscribe to a lot of newspapers. I do not subscribe to the New York Times, nor will I for their handling of this matter. So I've not seen this video. But it picks up even more points of the words that she chose to use in this article that bring her further and further out from under this protection. The first thing they mention is that she purported to tell the world what really happened. Now, think of this fair report privilege. This was created with a good purpose, a purpose I firmly believe in, and that's the freedom of information that we, the public, deserve. So if there are battles going on in court, we have a right as the public to know about these battles. We can attend the trials, we can have access to the documents from the trials, or alternatively, we can listen to or read news articles that keep us updated on what's happening, because not everyone has the time to actually go to these trials or actually access these documents. I firmly believe in this right. I'm happy that it's protected. I access court documents, sometimes free, sometimes I pay for these. But I firmly believe that it's the public's right to have access to these, to discuss them. But if you're going to claim this privilege, you have to comply. Now, on places like YouTube, we know that people are sharing their opinions. It's often stated, it's often implied, and even the way in which we choose to say what we say, we're usually careful that people know these are just our opinions on things and not some kind of expert legal advice, or that we're established news agencies. But when you're this sort of bastion, when you have declared yourself a news agency, one of the largest in the world, if not the largest, you bear more responsibility because you're claiming to report unbiased news. You're supposed to be a truth teller. Your facts are supposed to be correct. If you find out your facts are not correct, you are obligated to correct them. So when you say in your article that you're going to tell the world what really happened, you are basically making a promise to tell them the truth. And that would mean a truth that you have fully investigated and that you're completely confident that it is in fact the truth, verifiable truth. It talks about the claims they made alleging that the Wayfarer parties orchestrated a retaliatory campaign to tarnish Blake, having waged a smear campaign against Blake. The press enjoys the fair report privilege when faithfully relaying the contents of a filed complaint. But that is not what the New York Times did. It based its article and video on its reporter's review of thousands of pages of documents. This frames them as having been verified by the New York Times' own investigation. So, when they stated this, they forfeited the fair report privilege. Which is exactly what we've been saying, right? Do you guys feel excited? I was so excited when I saw this. And he repeats this over and over again throughout this entire document. And it felt so good because that's what we've been saying since the motion to dismiss. That the New York Times told on themselves when they referred to these thousands of pages. Because then it went beyond covering legal documents. They were testifying. And if this information had somehow been legally obtained through a subpoena, and I know I've talked about subpoenas over and over again, but this process says a lot. You can't just go to the courthouse and say, hey, clerk of court, I want to know this information that my neighbor has. Can you write me up one of them there subpoenas and let me take it to him and then get the information that you want? It's not how it works. The reason you have to go to a courthouse is because it's almost always linked to a current lawsuit. You have to put the lawsuit information on the application for the subpoena. There are a few states that do allow subpoenas for pretrial evidence, but that is also a quasi-legal process itself. In federal cases, it's not allowed at all. It's only allowed in certain states under very specific circumstances. So let's say she was able to get that subpoena. She doesn't just get to take that information and put it in her purse and then, run it down to the New York Times or give it to her publicist to share with the New York Times. That information is then waiting for the court to decide if it's admissible or inadmissible. Sometimes there's private information that gets subpoenaed, and you would think that Blake would understand that because her team is fighting so hard to get so many things kept privileged and attorneys' eyes only. But yet she claims she got this subpoena and she can just take the subpoenaed information and just share it with the New York Times. But this information comes back to your attorney or to the courthouse, and the judge rules on whether or not that information is admissible for your case. Now, we would know if the judge had already made this admissible. Justin's attorneys would know that if this subpoena was returned, given to Judge Lyman, and Judge Lyman had said, yes, this is admissible. But even then, does that mean you can carry it around in your purse and give it to the New York Times? No. Once it's been declared admissible by the judge, it's discovery. Where is the discovery for this case right now? Do we have access to it? No, we don't. It's behind the scenes. There are bits of it we will never see. We will never hear. The bits of it we will see are things that show up in legal documents. So these text messages that were in Blake's complaint, that were in Blake's lawsuit, that were in Justin's lawsuit, that were in Stephanie Jones' lawsuit, these are all public court filings. We get to see them. Things that don't make it into the documents but will make it into the trial, we'll hear them during the trial. We'll read about them in the transcripts. We'll hopefully get to hear them on audio. We'll see how that goes. But if they don't come up in the process of the trial or if they're not put in documents, we'll never see them. The New York Times is protected to cover legal documents. So even if there was this magical subpoena, that didn't give the New York Times the right to see it and to print about it and to be protected when they print about it or make videos about it. They're protected for relaying information from those documents to us. Anything that wasn't on the complaint, they didn't have protection to talk about. So all these thousands of pages, whether they were a subpoena or not, if Judge Lyman hadn't seen them, if Judge Lyman hadn't said, yes, these are admissible, they were not part of a court proceeding. They were not part of a court document. And again, if it was a phone record subpoena, that should have gone to the phone company, not to Jonesworks. Goes on saying that they prepared their salacious article, love that spice, before they contacted the Wayfarer parties. And there's no way around that. I have a comment here from one of my subs who actually worked in the business for 14 years. They said this kind of article is in the works for months, which according to internet sleuths, who know how to look at the metadata, and I had another comment from one of my subs too, saying that they know how to look that up and that they did look it up. This article was in the works for months. All of these things, whether it be obtaining a subpoena and getting the information and then getting that information marked admissible, to creating an article like this and its accompanying video, all these things take time. Months. I know how long it takes to prepare a video. I don't go live. I prepare my stuff, and it's so many steps. I used to write out the whole script. Now I take the legal documents and I mark up the margins with the points I want to make. I have a tendency to wander, so I kind of keep myself on an outline like this. My first read through, I circle any cases I want to look up, any federal rules that I want to remind myself of, any words I want to look up the correct definition to or the correct pronunciation to. Then my second time through, that's when I do all the research. All those things I circled, that's when I start to look them up. That takes hours. Some people can just sit down and talk about it. I can't. I don't have that ability. So once I've done all my research, I have even more writings in the margins, and then I start recording. Once I record, I go through and edit. Sometimes when I say something, I didn't like the way I said it, so I repeat it a second or a third time, so I have to go back through and cut out the ones I don't want. Sometimes I cough. Sometimes a train goes by. Sometimes I have to drink my tea. A million things have to be edited out. Once I have that done, then I put it in my video making software. Then I have to go through and select photos. I call them slides because of the old PowerPoint days. I used to make tons of PowerPoints, so I still call them slides. But I have to go through and select which slides I want to show you, or if there's a little video clip I want to show you. I put that in there. If I want music for my intro, I've got to put that in there. And then you've got to listen to it, make sure there's no mistakes, save it. If you're using 4K, it takes forever. And then I upload it to YouTube, just like they would upload it to their site. I'm a one-person show. I do everything myself. They have teams. So according to Felicia, these go from reporters to several editors to legal, then to the publisher and CEO, and that there are daily budget meetings to discuss stories to advertising ratio. Now you can imagine a story this big is going to get lots of attention, probably lots of meetings. I can really see this happening once she explained it this way. So thank you again, Felicia, for your explanation of this. So just knowing all these different parts that go into it, we know for absolutely certain that this article was not written and this video was not made after she filed the complaint in the California Civil Rights Department. So during all of this time, they could only give the Wayfarer parties 14 hours notice, let them know the night before. And that's why they put fact-checking in quotes. That's not responsible fact-checking. To have just unilaterally taken this one side, already prepared the whole thing, and then just give hours for the other side to respond. Another point that was mentioned in the motion to dismiss is that the New York Times claimed, and Leslie Sloan also in her motion to dismiss also said the same thing, complaining about the group pleading not being clear exactly who was suing who and for what. And they say basically the same thing they said in their memorandum response to Leslie Sloan, and that's that it's premature. This was a group effort that they needed discovery in order to determine who had what part in the whole thing. The New York Times didn't write this article on their own. Information was provided to them. So at this point, they can't say exactly, you did this, you did that. Oh, you didn't do that, but they did. That's what discovery is for, trying to determine who played what role in this collusion. And they talk more about this choice of law, and I love this, because we've been talking about this since that motion to dismiss was filed. They talk about these two tort claims, or these two causes of action, that New York doesn't even have. How unfair would that be? Two plaintiffs, who should be favored in court, as plaintiffs, by the way, to have to drop two of their tort claims, or two of their causes of action, because New York simply doesn't have it. They also mention, like we said, it's their personal and professional homes, and that's where the harm was suffered. And that is so key, where the plaintiff suffered harm. This is not in the defendant's favor. They also talk about this actual malice. Now, if you'll remember, I took issue with their definition of actual malice in their motion to dismiss. It was not a complete definition by any stretch of the imagination. They completely left out reckless disregard. And another thing I talked about in that first episode was them trying to have it both ways by saying, hey, we spoke the truth, so we're protected, but also saying, hey, this was opinion. Hey, this was hyperbole. Which one is it? You have to pick one. You can't just throw them all out there. Was it the truth? Was it facts? Or was it opinion hyperbole? But either way, they say that neither of these theories holds up. And they say again that if this motion to dismiss is granted, it should only be granted with leave to amend. And we talked about this too, how they've already both amended their complaints. At this point, they don't have permission to amend yet another complaint. And some cases, especially cases that go on for very long, will have multiple amendments to their complaints. So this isn't unusual, and the courts generously, liberally grant leave to amend complaints, because they understand that as you go along and you learn more in discovery, that there may be things dropped, there may be things added. But they're saying, please don't just dismiss. If you're leaning towards dismissal, please give us leave to make another amended complaint. And we have an important footnote at the bottom. They mention this metadata that I talked about just a moment ago that people found that you can follow when a picture was shared by its metadata. The New York Times said, oh, this is nonsense. And they're saying this is not the proper venue to raise factual disputes. Each of these documents we're going through has a specific purpose. And that brings us to the point about this motion to dismiss. What they're asking in asking the court to deny this motion to dismiss, they're saying, give us a chance to put this before a jury. The judge is not the deciding factor in this case. That lies only with the jury. So the reason that a motion to dismiss is rarely granted is because of that fact, that the evidence, if it's sound, has a right to see the light of a courtroom, has a right to be heard and decided by the jury. The New York Times wants it dismissed before it can even get that far. And the rules are such that make it very hard to get these things dismissed, because all of these introductory documents we're going through now, these are just the skeleton. They're the infrastructure. The case will continue to be built by the discovery, by the depositions. So right now what they have to prove is that they have enough of a foundation to show that it's not a waste of the court's time to proceed from here. So basically the biggest hurdle that they have to overcome right now, the only thing that's really an issue that could cause this to be dismissed, is this fair report privilege. That's most likely the only reason that the judge would dismiss this case, would be if he's looked at it and said, hey, they're protected by the Constitution, you can't win this, we're just not wasting any more time on this. So that's the purpose of this memorandum. It's not to fight all the issues, it isn't the time for that. This is about whether or not this case gets to go before the jury, and that's why it's so important. I feel like it would be a huge mistake and a huge shame if they don't get to put this before a jury. They mention again these new facts that they've uncovered, and that these facts could help support the claims. And they say this dispute should be resolved by a jury at trial. And then we have relevant background. This is told and retold every time, starting with the book, Justin acquiring the film rights, and how it went through there. I just love the little spicy points along the way, though, talking about Blake taking over the editing and releasing her cut despite its poor performance in audience tests. And then it goes on to the marketing, that she erased Justin and drove a light-hearted, frothy, self-involved promotional campaign, which resulted in harsh blowback from the press and the public, who viewed Lively's marketing as tacky and tone-deaf. And that's truly what happened. There's such a celebrity culture. People start to think that they know them, that they're friends with them or something, and they become so loyal. They're there just waiting for every Instagram post to like it, to comment on it, and that's fine. But when you're introduced to a new group of people, not people who were already following you, but in this situation, if we look at Blake's previous movies, it wasn't really anything of substance like this movie. But what came with this movie? This book was huge. This wasn't some little book that no one ever heard of that Blake Lively made famous. This wasn't Blake's first movie, but it was her first very successful movie. It wasn't because she was in the movie. People came to this movie because millions of people read and loved the book. There was a huge following on Book Talk before the movie. I believe I read it was on the bestseller list for half of the year. And then it was 5 years in the making. So 5 years people were waiting to see this movie. And a message like this wasn't some rom-com. This was a beloved, well-circulated book, a bestseller that people waited 5 years for because it was supposed to deliver a very empowering message. A message that was lost completely on Blake, apparently. People wanted to see the subject matter of this book be the focal point. They didn't want to see Blake standing in outfit after outfit. What was that? I can understand a flower theme as like set design, but people who were drawn to this story weren't drawn to the story because it was about flowers. They were drawn to the story because of the subject matter. So even if you have floral backgrounds and floral clothes, you have to address the subject matter. Now, in the marketing plan, he didn't want it to be depressing. It was about hope and strength. But in order for it to be about hope, you have to address, why do you need this hope? It was hope for something better. So you have to address, what was the thing that you needed hope for? What was the thing you needed strength for to make a difficult decision? Hope and strength are not about floral dresses and baking cookies. These people out there that are calling us misogynists, And that was bad enough, because I think powerful women wanted to see a story of a powerful woman. They wanted to see a woman in a bad situation decide that she wanted a better life for herself and for her daughter. She wanted to be stronger than what her mother had been. To think that women can only be out there looking pretty in floral dresses and cooking, that's missing the whole point of the strength of a woman. The way strong women looked at this movie is completely different than some flowery rom-com. That's misogyny to me. So people who were offended by, as he describes it, this frothy, lighthearted, self-involved promotional campaign, we were offended by that. That was authentic blowback from strong women who didn't appreciate seeing a strong book with a beautiful message of strength and hope be reduced to grab your friends and wear your florals. And let's not talk about abuse women go through. No one's hating on Blake because she's a woman. We hate that she ruined a beautiful opportunity that was right there in her hands, and she threw it away for arrogance and conceit, to pose in pretty clothes, picture after picture, to try to make money off of her alcohol line and her hair care line. That's why we were angry and disgusted, not because she's a woman. And now, this term, they're calling us mommy sleuths. Did you see that? You call us misogynists? And then you turn around and take a beautiful word like mommy. What's more sacred than that? And turn it into a means to insult us. Being a mommy means that you used your body to give life to another human being. It's miraculous. It's beautiful. It's a huge sacrifice that women make. It's not painless. Women die giving birth. And Team Blake is throwing it around as a means to insult the women who are spending their time investigating this, talking about this. Mommy sleuths. Is that supposed to be an insult? Is that supposed to demean us, like we can't be educated, strong, working women and be mommies? How does she know who of us that are talking about this are even mothers? Are you saying we should hang up our microphones and just go make babies? Leave this to the men? Is that what you're telling us? We don't belong here. We should leave this to the men? We should be off busy making babies? But we're misogynists? And it's not surprising, seeing how she spoke to the woman in the interview who congratulated her on being a mommy and in turn got insulted. And it turned out she was infertile, painfully infertile. I haven't seen a more misogynistic woman than Blake in a while. She then went on to say, oh, would you ask the men about the clothes? But then in interview after interview after interview, she goes on and on and on about clothes. Clothes are the character. How clothes help her get into the character. She took control of the wardrobe. But in an interview, she doesn't even know how to be a strong woman. She thinks being a strong woman is insulting someone for congratulating her on her pregnancy, or insulting her for asking about clothes. That's not what makes you a strong woman. It's not like she said to her, oh, your belly's so big. Oh, you're about to pop. But congratulations that you're growing life in your body. That's not rude. She's shared that she can't have a child of her own. Who knows? It could have been painful for her to even acknowledge that Blake was sitting in front of her pregnant. That could have been painful for her. But she doesn't get to do that. And her kindness was met with that nastiness. But Team Blake, you really need to look up the word misogyny. Research it deeply. Find out what it actually means before you go throwing it around. Because you've got it wrong. Mommy sleuths? Meant as an insult? These are the reasons people don't like Blake. These are the reasons she got criticism on her Instagram. And when you're that egotistical, and you post picture after picture in your pretty clothes, and you're expecting everyone to come there and tell you how beautiful you look, and instead they say you're tone deaf, and you can't face the fact that you earned that criticism, so you gotta go and sue somebody because you think they did it, because God forbid, someone might organically dislike you or dislike your actions. And now that I'm this angry, let me just add, I've mentioned Jamie and Justin's wives several times, but let me say again, how much self-control these two women have. I am not built like that. If I were these women, you'd have to chain me in the basement because I would be screaming to the world, what makes you think my husband wanted you? How dare you humiliate me like this in front of the world by telling the world that my husband wanted you, with sneaking peeks at your breastfeeding, when you were the one sending him texts about yourself, calling yourself yummy and flirty, using expressions like no teeth. There's not a single message that these guys sent to her that was out of line like that. She's sitting there with a wall of text describing herself as flirty and yummy and in her teeth and wanting to act the scene out for him. What does he say when he comes back to the messages? I was crying my eyes out because my family's leaving for a few weeks. He wasn't thinking about her being flirty or yummy. He was holding his family and crying, saying goodbye to them because he was going to miss them so bad. He was not thinking about Blake and her teeth. And maybe that's what made her mad. Who knows? Their wives are beautiful. Justin's Instagram is full of pictures of his family, his beautiful wife and his beautiful children. But all my respect to those two wives for all of that self-control. I do not have that kind of self-control in me. I get heated talking about these people I don't even know. Try to make a fool of me like that in front of the whole world. So hats off to you girls, because you are strong women. I have the absolute utmost respect for you ladies. Truly. And I can't imagine how many tears you've shed over this. Even if it's tears of anger and frustration at seeing the man you love be maligned this way. The humiliation that you're feeling, whatever you're feeling. Just know we are not misogynists. We support women, and we support you. You are the strong women in this story. In paragraph 2 on page 4, once this criticism came to Blake and she couldn't own it, she's embarrassed by it. What does she want? She wants Wayfair to stand up and say, oh, this is all our fault. It's our fault her marketing campaign's so awful, even though it's run by her husband. And we've now seen leaked video of that hideous video with Ryan and Hugh Jackman and Ryan's mom. It's so bizarre. I didn't show you the whole thing because I didn't want to get copyright struck. But that thing is hideous. Ryan's mom sitting there throwing herself at Brandon, talking about her husband is dead, and Ryan saying he's looking for a new daddy. And what did we see in the behind-the-scenes videos? Who's directing her mother-in-law to say this bizarre, creepy stuff? Blake. And they're all in their matching shirts, doing this weirdo marketing about a domestic abuse movie. How does that show hope and strength? But it's Justin's fault, guys. Justin made them do that weird promotion. It's his fault. And they wanted him to sign a document saying that, so that people would stop calling Blake out. It's Justin's fault. Even though we've seen emails where they saw the disastrous turn the marketing was going, and Jamie Heath says, hey, you might want to turn this marketing around a little bit. It's not looking so great. It's not going so great. You might want to stick to this. But they knew better. And then when they got booed for it, oh no, that's Justin's fault. Here, sign this paper, Justin. Tell him it's your fault. And he said no. And he wouldn't take it anymore. So what happened? Just like when he said no about the dailies, and that's when she took everything over, that's when she got nasty, he said no again, and wow. Then we got this. As they said, relying heavily on deceptively spliced private text messages stolen from Abel's phone by her former employer and Baldoni and Wayfair's former publicist, Stephanie Jones of Jones Works. They just outright say it here. They don't even bother with the word subpoena. They just say stolen. And by the way, I still think that's some of the new information they want so bad to put in an amended complaint. Now they point back to this New York Times article, and they quote from it saying, the documents show an additional playbook for waging a largely undetectable smear campaign in the digital era. They mention again, by New York Times' own admission, they did not rely solely on the CRD complaint. They say those words again, those words I've said so many times. These thousands of pages of text messages and emails that they admit to reviewing. They point out it's also confirmed in the video that the statements were based on private text messages and other documents. And this is the quote from earlier. What really happened? Now, those words are very problematic. What really happened? When you make a statement like that, you're not just relaying information that's on a document from a judicial proceeding. You are claiming to be in the know. You are claiming this happened. They didn't say allegedly here. And they clearly say smear campaign. I mean, it's in the title of the article. Hollywood smear machine. In the video, they say it's impossible to know how much the Wayfarers planted and how much of it was originating organically. Whatever the case, they seized on it and amplified it. Do those sound like opinions? It says they published an article and a video advancing a factually false and defamatory narrative based on deceptively spliced and cherry-picked text messages. Now it must answer to them. And now we get to something I touched on earlier, and that's this legal standard about 12b6, which is the rule that they base their motion to dismiss on. It's very easy to satisfy this. A plaintiff must state enough facts to state a claim to relief that is plausible on its face. That's all they have to prove. That it's strong enough to stand before a jury. They don't have to plead their entire case right now. They just have to show that one member of a jury would look at this and say, oh, there might be something to this story. It's a very generous standard. And what makes a claim plausible? When the plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. And as I said, many of these things are in the plaintiff's favor. When the court is ruling on these things, they have to keep that in mind, that these things are in the plaintiff's favor. The court must accept the factual allegations as true, drawing all reasonable inferences in favor of the plaintiff. I mean, personally, I don't see how he can just turn his back on all of this and say you have no case. I really, truly don't. And again, we get back to this, that they don't have to fully put their entire case in these. All that they're required to show at this time, pre-discovery, because remember, the New York Times, when they filed their motion to dismiss, they also filed that motion to stay discovery. That means during this time when everyone else is already sharing discovery, the New York Times hasn't had to share a thing. So there's only so much that they even can have at this point against the New York Times. So this pleading doesn't have to have the entire case laid out. It need only contain a short and plain statement of the claim, showing that the pleader is entitled to relief. Specific facts are not necessary. The pleading need only give the defendant fair notice of what the claim is and the grounds upon which it rests. I don't think the New York Times is in any doubt what these accusations are. It's very plain here. I don't think they need more information to understand why they're being sued. And the very court that this is being argued in has noted in the past that Rule 8 does not necessarily require that the complaint separate out claims against individual defendants. There are multiple complaints, there are multiple defendants. And they're being accused of conspiring together to do this. At this point, especially without the New York Times discovery, they don't fully know all the details of the conspiracy. So if they say, oh, this person we're only putting this cause of action to, but that one's getting 3 causes of action, they don't know at this point until they get a full picture of what the whole conspiracy looked like. Right now, all they have to prove is that this matter has a right to be heard before a jury and not dismissed. As they say, they coordinated a near simultaneous drop of the article, the video, and CRT complaint. And then throw in Stephanie Jones' lawsuit as well. We're talking December 20th, the CRD complaint. The 21st, the New York Times article. The 24th, Stephanie Jones' lawsuit. The 31st, Blake's lawsuit. This all happened within 11 days. This kind of stuff doesn't happen on an instant. Every one of these things took time to get ready. This is all coincidence? Then they talk about the reckless disregard as to their falsity. That's all they need to prove actual malice. They don't have to prove that the New York Times knew it was false. That's the first definition. But without the rest of the definition, people could just claim ignorance. Oh, I didn't know. Well, why didn't you know? Because of your reckless disregard. You didn't try hard enough to find the truth. So they're saying, hey, in our complaint, we said you conspired over a matter of months. Then they say the New York Times involvement is carefully concealed and impossible to ascertain fully without discovery. Again, their discovery is stayed. They're not having to share anything right now. They're saying, hey, we have this source code, October 31st, which makes more sense. This backlash started in August and progressed from there. Why would all of this have waited till end of December? They wait till the holidays to do this? Or did she contact an attorney and her publicist back when the backlash started in August and September, to where they had something thrown together in October to start this process? Doesn't that make more sense? Now, this was mentioned in Leslie Sloan's case as well, talking about the cited cases that the New York Times put, saying that they're in opposite, that they really just don't apply. They are so different to this case that they're really not comparable. For example, this Komatsu versus City of New York, there were 200 claims against 125 defendants spread across 1,713 pages. The other case, and I talked about this one before too, but there were no differences shown between the defendants, and there were no identifiable factual basis for the claims despite multiple amendments. That hasn't happened in this case. So what do either of these have to do with this case? You're supposed to find cases that are similar as you can find. And then we're back to the California versus New York law. And as I've said since the very first motion to dismiss, in diversity cases, federal courts apply the choice of law rules of the forum state. Defamation is a very special tort. It's different than where an accident takes place or where a theft takes place. Publication has been defined in federal courts and Supreme Courts as being where the pain is felt. When someone slandered someone on Facebook, it had nothing to do with the state where it happened. It had to do with where the plaintiff lived, where they felt the pain, where they were ostracized, criticized, humiliated, where they live, where their family lives, where they work. They can't easily escape these things and shouldn't have to. It's about where their name deserves to be cleared, and that's where it needs to be cleared, is where the damage was done. The other problem is that it says if the applicable law from each jurisdiction provides differing rules that have the potential to affect the outcome of the case significantly, that's a conflict. We have that here. There are 2 of his claims that aren't even recognized in New York. How does that not affect his case? And this line, I love this so much because it's what I've been saying. My whole Great Wall thumbnail that I made. New York law goes in excess of the United States Constitution. It goes beyond the very law of the country. It provides for absolute protection of opinions. But that's not what the United States Constitution provides. California law is in harmony with the Constitution. And so they say this is another substantive conflict. And they state what I've been saying. Under New York choice of law rules in defamation cases, the state of the plaintiff's domicile will usually have the most significant relationship to the case, and its law will therefore govern. It also talks about the parties' domiciles and the locus of the tort. That means the location where the defamation took place, because in this case the tort is defamation. And it also has to do with where they conduct their business. This is a suit against Wayfarer. Wayfarer is in California. And they point out that nearly all of the plaintiffs are residents of California. And even though Steve Sarowitz is in Illinois, he's a part of Wayfarer, which is in California. It cites this Condit case where reputation was a matter of national significance, but it mattered most in California where he had been elected to office. New York Times wants to say, well, the article emanated from New York. But they point out, in fact, without discovery, we don't know where this story was created. A lot of things are done from your home or while you're traveling. We don't know where the stuff was uploaded, where it was discussed. But they say regardless of all that, California has far more powerful interest in the application of its law than the states at issue. It involves Hollywood's entertainment industry. And they point to the title of the thing, Hollywood Smear Machine, showing the subject's connection to California. Blake's complaint, filed in California. And the movie was not filmed in New York, it was filmed in New Jersey. And when talking about defamation, it needs to be seen and understood as libelous on its face. So we're not talking about needing to be trained by law to understand completely all of the ins and outs of defamation. We're talking about the average person reading this article, looking at it, could they say whether or not this is defamation? Allegations of sexual misconduct are defamatory if they're false. Saying they took revenge because of this misconduct is also the kind of thing that brings someone to public contempt, ridicule, aversion, disgrace, people holding an evil opinion of them. We've seen this. He lost one of his awards over this. Now we come back to this fair report privilege. Under California law, the privilege is 1. Report on the contents of a judicial or other public proceeding, a fair and true report of the proceeding, and be published in or made to a public journal. A report is not fair and true if the publication deviates from the judicial proceeding such that it produces a different effect on the reader than the actual truth of the proceeding. And they point out that the New York Times offered their own commentary going well beyond merely reporting on the complaint. It points to their statement that text messages show what really happened. That's not an opinion. That's them making a claim. And from the text messages we've seen, that's a false claim. And then these thousands of pages, they're well beyond this complaint. Now it talks about California law on what constitutes defamation. They must list it as statements of fact and not opinion. And they say expressions of opinion often imply assertions of fact and are therefore actionable. Thus, a statement in the form of an opinion may be actionable if it is implied that it's based on some undisclosed defamatory facts, and ultimately reminds us that the issue of whether the statement is fact or opinion is one for the jury. This is up to the jury to decide. They say the New York Times article not only stated that they engaged in a smear campaign, but that they also operated or were a part of a Hollywood smear machine, and that this goes beyond even Blake's allegations in her complaint, and therefore imply misconduct on a larger scale than what's at issue in the CRD complaint. And I mentioned this in the last episode about the assertion of a smear campaign. They called it hyperbole. And I even asked, when we hear smear campaign, is it that hard to define? Do we not understand what that means? We do. Black's Law Dictionary, which is like the Law Bible, defines the phrase smear campaign as the deliberate telling and repetition of untrue or distorted stories about a person in order to make others lose respect for that person. Right there's the definition. It's not too hard to define. Then they find fault in the cases that the New York Times cited in this aspect as well, stating that it was a blackmail case, not a smear campaign, and that the defamatory statements were things like sucker and fool. That's name-calling. Name-calling is way different than accusing someone of a bad act. And this was not written in an editorial section or a letter, but it was an explosive feature-length expose reported on by the New York Times Pulitzer Prize-winning star journalist, Toohey. And they gave their words credence by saying that it was based on their own review of thousands of pages of text messages and emails. If that's not trying to assert something is fact, I don't know what is. They were presented as statements of fact based on first-hand knowledge of the evidence. A reasonable viewer would have interpreted the New York Times smear machine and smear campaign statements not as mere hyperbole, but instead as provable, verified assertions of fact. Statements of this nature are not shielded from suit as a non-actionable opinion. These are accusations of grossly immoral conduct to cover up even more grossly immoral conduct. These are the kinds of things that destroy reputations and careers. They cannot be and were not construed as mere statements of opinion or hyperbole. They were false statements of fact. They point out, as we did, to plead actual malice, a plaintiff must allege a statement was made with knowledge that it was false, or, the part the New York Times left out, with reckless disregard of whether it was false or not. And they're saying that the Times didn't fail to adequately investigate. But they did investigate because they say they reviewed all of these thousands of pages. There were pages in there that disproved what they published, but they published it anyway, even editing and splicing documents to mislead viewers. So they're saying armed with this voluminous evidence, they either knew or recklessly ignored proof that the contents of its article and video were factually false. And that this notion of an untraceable smear campaign, by definition something that's untraceable, means it can't be proven. So putting that in print, highly reckless. There were obvious reasons to doubt the veracity of these statements. And then they point to an article in the New York Times itself back on August 17th. What's it entitled? It Ends With Us, the press tour drama explained. And they reported on her public missteps. So they knew that there was organic criticism of her. They were part of it. And they mention among those thousands of pages of text that there were texts that clearly said that these people were not behind these articles that were coming out. And then again, as I said, this reckless disregard was deliberately waiting to the last possible moment to seek a response from the Wayfarer parties. There was a purposeful avoidance of the truth. The moment the Wayfarer parties denied the allegations, wouldn't a responsible journalist, a responsible newspaper have said, we better look into this if they're denying it. We better ask them some questions. Hey, we just gave Blake months to go through this. Can we not give them a little time to go through this? And as I said, one of the people's text messages that they were looking through and posting about was Jennifer Abel. Jennifer Abel gave them a very well-written denial. She mentioned a lot of things that should have piqued their interest. And if they were truly trying to get to the bottom of it, they would have investigated her claims. The fact that they didn't shows they were only interested in the one side of the story that they had covered. And it really makes me think she thought she had another Harvey Weinstein story. She didn't want the other side. She wanted that attention. Well, now she's got some notoriety. They point to this overnight window of time. Like I said, they gave it to them hours before most people go to bed. It's published the next day at 7:11 a.m. California time. That was already set up by the time they even notified them. It takes time to arrange all this stuff on a website. It takes time to arrange all this stuff in print. And then the Times had also claimed that nowhere was it implied that this article wouldn't be published until noon. And so there was no sort of contract between them. But her emails that she sent to each of them said that she needed to hear back by noon Eastern. When you read that written in an email, doesn't that tell you that's the deadline? You have till this time? Don't you expect nothing to happen until that time? And so they conclude, saying that the Wayfarer parties respectfully urge that the court deny the motion in its entirety. In the alternative, should the court be inclined to grant the motion in whole or in part, the Wayfarer parties respectfully request that they be granted leave to amend their pleading, as stated herein. Respectfully submitted, Mitchell Schuster and Brian Friedman. And then we have Jason Sunshine, who's also with Brian Friedman's firm, and he submits Exhibit 1, which is the transcript of the video. And in the very first paragraph, private text messages and other documents that we've obtained reveal what really happened. This is supposed to be based on the CRD complaint. Nathan assembled a team that could dominate social media through full social account takedowns. They seized on it and amplified it. In one message to the publicist, Nathan wrote, "Socials are really ramping up in his favor. She must be furious. It's actually sad because it just shows people really want to hate on women. You know what's interesting about this line? Stephanie Jones uses this text claiming that it's about her. That's in her lawsuit. And then here we have Blake in her lawsuit claiming it's about me. Which one is it? And so that concludes this document. Now, I'd started recording talking about the hearing, the decision that was made about the attorney's eyes only. I think that's been pretty well covered out there by now. I'm a little late to that one because I wasn't able to get to this earlier. I wasn't feeling well for a few days and then had some other family obligations to take care of. I'm also working on a top secret project that's very, very interesting and very, very important that you will hear more about soon, but I can't tell you about it now. But just know that there are things that keep me from being here as much as I would like to be. So I won't really get into that. I mean, basically there was something granted, there was something denied, but here's what it comes down to. There will be a designation for specific things that should be kept private. Personally, I don't think it was necessary, but I think the judge recognized that not allowing it, at least to a limited degree, could backfire on him later. Judges have to keep in mind all through a trial that there are lots of things that a defendant, if they lose, will later tear apart in an effort to file an appeal. So the judges strive for all of their decisions to be correct decisions, or things that are not going to come back to them in an appeal later, saying the judge erred with this ruling. So some decisions are made a little on the cautious side, and you can't blame them for that. In the end, it's better for the plaintiffs if they win, because it does reduce the amount of things and the time that they can put towards appeals in the future. And by now, he's seen the troublesome nature of some of these people and knows what would happen if something got out. So he did grant this, but you can also see in his wording that he did pay attention to Brian Friedman's words when he expressed fear that they were going to be in the court over and over and over again, that Team Blake was going to misuse any kind of attorney's eyes only designation. So he did spell out very meticulously what could be considered attorney's eyes only, and did warn against them using it excessively. So I heard everybody was heralding Team Blake's win. It was a reasonable grant. It's not some huge win that's going to win them the case. It's just a cautious step to guard people's private information, which is supposed to be protected anyway, and a warning not to overuse it. I don't think it's the last we'll hear of it because I don't think Team Blake is going to be able to resist not overusing it. So I feel like personally we'll be back in court battling what actually falls under this designation. It's just so funny to me that it's been Team Blake that's been the one crossing the line with these suspicious subpoenas that they subpoenaed Jones Work, not a phone company, and these phone subpoenas that they put out against all the Wayfarer parties wanting stuff from 2022. And then they're going to be the ones sitting around crying about not having too much shared. It's a bit ridiculous. So like I said, I fully expect there to be more fights about this very topic. I don't think that's going to be the conclusion of it at all. But I really don't want to devote a whole episode to that. So I just wanted to throw it in here. Again, thank you all so much for your wonderful comments. And those of you who've offered expertise like Felicia, and of course all my members for your support, all my longtime subscribers that named themselves Cassidy's Crew a long time ago. You guys are the reason I'm still here. So thank you so much for that continued support. There's quite a few of you that I look for every time. Also, I want to address there's been some problems with some of your comments being deleted. It's very frustrating to me. Just know I am not a deleter of comments. There is a failsafe in YouTube where if they see a word that they think is possibly problematic, they will put it in a folder and let me review it and decide whether or not I want to approve it. But these aren't even coming there. They're just disappearing, and it's from people like Nirvana, I'm pretty regular in my comments, that I know would never, 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 ever put something inappropriate there. So they just disappear. I never even get to see them. So just if that's happening to you, I apologize. It's not anything I have been able to find a solution to do anything about. But another thing I've noticed happening, which is very weird, is I go through and do a thumbs up and a heart, and I'll come back and they'll be gone, or there will just be the thumbs up and no heart. No one else has access to my account, so I don't understand what's happening here, why it's going away. So if you saw that I hearted your comment and then it looks like I took it away, please be assured I did not do that. So I don't know what's going on. There's been a few odd little things happening on YouTube lately. So sometimes there's glitches and they get worked out. So hopefully it does. And just after editing and preparing to put the slides on, I just happened to check the docket. Leslie Sloan, who last week filed another memorandum in support of her motion to dismiss, has now, just like the New York Times, filed a motion to stay discovery pending the decision on their motion to dismiss, claiming that they have shown good cause to dismiss the claim against them. fat chance, Leslie, and then go on to cry that the discovery that's being sought is unduly burdensome, that the Wayfarer parties have served a striking 370 requests for production of documents and 18 interrogatories on the Sloan parties. There is very little chance the court is going to grant their motion to dismiss. I'd say get started on those 370 requests. And we also learn that the Wayfarer parties have served extensive discovery requests on Blake, Ryan, and 10 third parties. So that was interesting to hear. But thanks again for joining. Till next time, this is Cassidy O'Connell saying stay well and stay tuned.